If you are applying in another jurisdiction, remember you'll need to get the materials for this course, which are online. I'm sure you've all pre-read them. And you'll also need a copy of the program from this conference. Any questions, you can come to me.
All right, we'd like to thank you to the Religious Liberty in the 21st Century panel. We have a great lineup of panelists, and I expect we'll have a great conversation here. I'll go ahead and just introduce the moderator of this panel, Elder Wickman, and he can introduce the other panelists as he wishes. So, Elder Wickman is General Counsel of the Church of Jesus Christ of Latter-day Saints. He received his law degree from Stanford Law School in 1972, and thereafter practiced law at the law firm Latham & Watkins in San Diego and Los Angeles. Since 1994, Mr. Wickman has worked full-time for the Church of Jesus Christ of Latter-day Saints in various administrative and legal capacities, culminating in his current position. And I'd like to have you all join me in welcoming the panel.
Well, I guess I should say one thing to clarify something. My full-time service for the church began in 1995, and like most of everybody else here, we've all been involved in various positions serving in the church in a lay capacity, and that certainly was my experience previous to that. Let me just introduce our panelists briefly. I want to say something about this general subject area and then something about the ground rules that will follow here today, because we're anxious for this to be fast-paced, we're anxious for it to be thought-provoking, we're anxious to invite you to participate. Seated to my immediate left is Helen M Alwari. She's an assistant professor of law at George Mason University and was prior to that an associate professor at Catholic University's Columbus School of Law. She earned her law degree at Cornell University, and she has a master's degree in systematic theology from the Catholic University of America in 1989. She's practiced with the Philadelphia firm of Stradley, Ronan, Stevens & Young, specializing in commercial litigation. But for a number of years, she was actively affiliated as a very important staff member at the U.S. Conference of Catholic Bishops, both in the Office of General Counsel and then later with the Secretariat for Pro-Life Activities at the National Conference of Catholic Bishops. She has a very distinguished resume. She has written much, spoken much, and we're so honored to have Helen join us for our panel today. To her immediate left is Eric Baxter. Eric is now a senior counsel at the Becket Fund for Religious Liberty, where he began his service in 2011. Prior to that, he was at Arent Fox here in Washington, D.C. He graduated from the BYU J. Reuben Clark Law School, where he served as executive editor of the BYU Law Review and was elected to the Order of the Coif. He speaks Russian and some Spanish, and is a member of the bars of Utah, Maryland, and the District of Columbia. Then to my far right is Vaughn Keach, who will be known to most here. Vaughn is a 1987 graduate of the J. Reuben Clark Law School. He graduated first in his class, I can tell you. Following law school and after working briefly at Sidley and Austin, he clerked for Judge George Pratt on the Second Circuit, and then later for Justice Antonin Scalia and on the U.S. Supreme Court, and had the distinction of being one of Justice Scalia's clerks when the Smith versus Employment Division case was decided by the court, Justice Scalia having written the opinion on that 5-4 case. So Vaughn has really had an insider's look at one of the most important religious liberty cases to be addressed in recent decades. Seated next to Vaughn is Jeffrey Moon, who is a graduate of the Case Western Reserve University School of Law, belongs to the bars of Ohio and the District of Columbia. Jeff is a solicitor, really assistant general counsel, I think is correct, at the U.S. Conference of Catholic Bishops. We in the Office of General Counsel have had, including our friends at Curtin McConkie, have had a very warm and cordial relationship with the lawyers in the U.S. Conference of Catholic Bishops. We've worked together on many matters and of common interest and concern. We think so highly of Jeff and are honored that he would join with us today. And then seated immediately to my right is Jim Sonny, James A. Sonny. Jim is very recently appointed to be the first director of the new Religious Liberty Clinic at the Stanford University School of Law, the only one of its kind in the country. Jim is a graduate of the Harvard Law School. He practiced with McGuire Woods and with Horvitz and Levy. And immediately prior to his appointment to the Stanford Law faculty as director of this Religious Liberty Clinic, he was an associate professor of law at the Ave Maria School of Law. So we have a very distinguished panel with us today. Now, we have, I'd like to just give a brief overview of this subject and then tell you what our ground rules will be, because we have some questions that are prepared to invite our panelists to respond to. These are in the neighborhood of hanging curveballs for them to swing at. I was not able to be here until yesterday for the meetings. I understand that Elder Holland did a spectacular job. I had a chance to visit with him before he came out for this. I want you to know that this matter of religious liberty for the Church of Jesus Christ of Latter-day Saints is not just a lawyer thing. It's not just something that we think and talk about in the Office of General Counsel. But it is in very deed a prophetic priority for the First Presidency and the Quorum of the 12 Apostles. It's very important that, that you realize that they're very concerned about it, but not in a vacuum. For the brethren, for the First Presidency and the 12, there are really three issues, like three legs to a stool, which are all closely related. And if you think about them, you see that each one depends on the strength of the other. And they're concerned about them not only for Latter-day Saints, but for men and women of all faith groups. The first of these, of course, is faith. That the strengthening of faith, the strengthening of our faith, in the case of us as Latter-day Saints and the Lord Jesus Christ and his teachings and his mission. Second is family, the importance of family. I was so pleased in the remarks that were offered in the last panel by the Chief Judge of the D.C. Circuit, talking about the importance of family and others mentioning the importance of family. It's reassuring to me that that distinguished jurists and one of the most prestigious courts in the world are concerned about that matter. And then the third, of course, is religious liberty itself. And there are a number of challenges that, that religious liberty is facing. I think that I've spoken to this group before about this subject of religious liberty, so I won't repeat in any, to any significant extent what I've said previously, except that they say this. The challenges to religious liberty seem to be coming from several different directions. One of them is a growing clash, being a secular concern about sexual rights and the rights of religious conscience. We see this in the HHS mandate cases, some 45 of which I think are pending. Numbers of you who are here, our friends from the Beckett Fund who are here, are very much involved with those and others. Challenging the mandate by the Department of Health and Human Services issued a little over a year ago requiring all employers, including even religious employers, to provide abortifacients and contraceptive services as a part of the medical plans for women employees. This is the Obama administration, after the filing of a plethora of these lawsuits, which have gone in different directions, some dismissed for a lack of standing or an immediate question, others having, including here in the D.C. Area, have been given some traction. Recently, the Obama administration has announced a broader exemption from this mandate, but even that has not been satisfactory to many, and I'm sure that some of our panelists will make reference to that. Of course, there's a clash between those advocating for gay rights and those who are concerned about institutional and individual rights of conscience. But we also have other dimensions of the religious liberty challenge. First, we certainly see it for those from minority and unpopular religions. We also see challenges with respect to land use laws, which sometimes reflect a NIMBYism about having a church or a synagogue or a mosque close to where people are living. And these and there are others, but there is also it's important to know that we can also slice this a different way between institutional rights and rights of conscience. One of the things that I've noted is that it seems to be easier to protect the institutional rights of churches than it does the rights of conscience of individuals, both legislatively and otherwise. And there's a real tension there in the area of religious of protecting religious liberty, and I'm sure that will be addressed by our panelists. I've asked each of our panelists what we're going to do. I have a list of questions here. We'll nowhere near get through all of the questions, but I've asked our panelists in giving their response. I'll ask a couple of them with each of these questions to take a couple of minutes each on it. We'll move on to some other questions. If other panelists want to chime in on a particular question, they're welcome to do it, but we'll try to keep our answers brief. And then we want to leave ample time in a little while for you to pose your question to this very distinguished panel of experts on the subject. So let me begin with the first question. And I'd like to invite Vaughn and Helen to respond to this one. As you see it, what is the most encouraging development you've seen in the field of religious liberty in the last few years? So Vaughn, we'll start off with you, and then Helen, please.
I think I would mention just two or three quick things in the 2 minutes that I have. Elder Wickman never fails to hold Smith over my head. I have a book that I'm going to write about Smith, but that has to wait until Justice Scalia leaves the bench and no longer keeps the promise of confidentiality that he asked all of his clerks to keep. But I think one of the bright spots about the very dark cloud of Smith is the court seems to mean what it said about exceptions, and you know we talk about Smith all the time and what it means, but if you look at Hialeah, which followed up after Smith, that's the animal sacrifice case, and if you look at Gonzalez against El Centro, that's the drug use case, the RFRA case. It really does seem that the court is willing to say, look, a law has to be truly generally applicable and neutral. And we're not going to allow government to gerrymander that. We're not going to allow government to with a wink and a nod, discriminate against religious liberty when, you know, through some pretext of generally applicable or neutral law. And I think that's been a big help. I think the one case that is the biggest bright spot in the 20 some odd years since Smith was decided is Hosanna Tabor, and the establishment of a ministerial exception cases for churches that really help in a church autonomy sort of sense, allowing churches to determine when and how they're going to employ or call their religious ministers in a fairly broad way. That decision was 9-0, and I'll note just to conclude, rejected the government's, the Department of Justice's argument that there should be no exception at all for churches, that it was fine for government to regulate the employment of ministers and pastors and other important church employees. And I think that's probably the one important bright spot that we can point to in the last few years.
Thanks, Juan. Helen, please.
Thank you, and thank you for having me on this panel. I say I'm as much of a fan and less of a colleague of so many of the people here, beginning with Elder Wickman. So I would agree on Hosanna Tabor in a very big way, and I like it for a reason that is just a slight variation on what was already said, which is that it actually revealed the extremism of the administration's thinking on religious freedom. And it's one thing for people who oppose it to say that. It's another thing for it to come out of their own lips. And when they suggested that a ministerial exception essentially does not exist, that's something that you don't have to say a thing then as a religious liberty attorney or a believer. You just point to it, and that's very helpful. And because it was so extreme, I think it provoked a strong response from the court. And the language that was used by the justices in response, words like remarkable, et cetera, that are the Supreme Court version of earthquakes. Remarkable. I thought that was very useful. The other thing extends to a point that Elder Wickman made regarding a chief, and this is something I think is a very good development. One of the chief contestants for religious liberty nowadays, one of our chief areas of problem, is the question of sexual rights. I use the language sexual expressionism. A guy at Harvard, Lance Pritchett, uses the expression sexualityism. The idea that sexual expression in and of itself is the good, having nothing to do with building a relationship with a spouse, having nothing to do with conceiving a child. That the good is to be able to have this expression. And that is why the administration, for instance, put forward an unmarried, well-off law student from Georgetown University as its symbol of what it meant by its position, which she sort of embodied it. The point of promise that I see is that the literature regarding this claimed good as a human right, as a freedom, is robustly moving against sexual expressionism. The idea regarding what is good for women, and you see it in the law and economics literature, the law and psychology, law and sociology, the idea of what it is that makes people free, what it is that helps make them happy, financially stable, able to marry, stay married, avoid cohabitation, avoid abortion, avoid non-marital birth. The evidence is moving very robustly and very strongly in the direction of a marital commitment and marital children and stable rearing of those children. And to me, I know you think of that as a step removed from the religious freedom equation, but it is what they are using to batter religious freedom. But I think substantively we are winning that conversation and need to make that plain.
Helen, while you've got the mic, and maybe just playing off of what you just said, what do you see as the most discouraging thing you've seen with respect to religious liberty? And you've sort of touched on that already, but anything else you'd have to say about that?
And I was glad you said that we might not get through all the questions, because I wanted to say this as well, in case we didn't get to this question, which is the whole notion, and the sexual expressionism comes under this umbrella, that religious freedom is the enemy of women. That, I think, has been the most discouraging development. And the re-election campaign of President Obama, and I'm trying to say this as factual, I'm not taking political sides on this, but it is very clear that the language and the tone of that campaign, using Sandra Fluck, who I debated at Albany Law School, she was a paid campaigner for that campaign, moving through all the states with the message that